back in 2006, my boss, Justice George Nicholson of the 3rd District Court of Appeal, was asked to speak at the Utah State Bar Convention. For some reason, they decided to hold that in Newport Beach. I don't know why they'd leave Utah to go to Newport Beach. Anyway, at the very last minute, due to a medical emergency, Justice Nicholson was not able to appear, and so he called his friend, Justice Fybel, who graciously accepted and went to the convention and gave a talk. And it was so good, the Utah Bar published it in the Utah Bar Journal, and you're free to look that up on their website. He is, for our purposes today, an expert on the topic of the German judicial system under Nazi rule and the Nuremberg trials. He has spoken and published on this topic at great length across the state. His expertise has provided him a number of unique opportunities. He currently co-teaches a seminar at Chapman University School of Law on the topic is the Holocaust, Genocide, and the Law. In 2010, he helped plan and participate in a Holocaust memorial program that was sponsored by the United States Holocaust Memorial Museum. And just last summer, Justice Fybel had the rare opportunity to give a keynote speech in Nuremberg Courtroom 600 in observance of the 70th anniversary of the Nuremberg trials. A great honor for him and a great honor for us to hear from him today. Without further ado, please welcome Justice Richard Fybel.
Thank you, Doug. Welcome to everyone, and thank you for asking me to be here today. I should ask you the same question everybody else is asking you. Can you hear me okay? Okay. I'd like to thank all of you for coming, and especially my colleague and friend, Justice Duarte. I was very impressed with the fact that you're having this program. I saw that the mission of the BYU Management Society is growing moral and ethical leadership, and I understand from Doug that this is your annual session on ethics. So that you can see from my subject matter, I'm going to take you from basically 1933 all the way through the main Nuremberg trial, and then I'm going to conclude with talking about the German judges and the trial of the judges after the main Nuremberg trial that was depicted in the play and the movie Judgment at Nuremberg. So how did I come to be interested in this subject? There are really two reasons. One is my family history. My mother was born in and escaped from Lithuania in early 1939, and my father was born in and escaped from Germany in the summer of 1938. They both made it safely to America, where they met and married and had a family. Millions of others in their exact same situations did not make it out. The second reason is that after I became a judge, I became very interested in the whole subject of judicial ethics and wondered how could a civilized society in the 20th century, with a rich tradition like Germany had of governance and a legal system, how could this terrible the Holocaust and all the murders of millions of people happen when you had lawyers and judges and a judiciary in that system? So I started researching those issues. And so what I want to do this afternoon is give you an overview of the German legal system from 33 to 45 and ask yourselves, which I try to ask myself, how were millions of lives destroyed? How were freedoms stolen? All as an official policy and practice of a nation state in the civilized world in the 20th century. The chilling, core, and yes, disturbing message from what I'm about to tell you is that everything the Nazis did was legal under their system. What we'll see is this incremental use of written law. It started in 1933 in January to set the stage. Germany had a civil code that was enacted in 1898. It had an established and well-organized legal system. Hitler then was the legally appointed chancellor. And the Nazis from the very outset recognized the importance of written laws, and they relied on written laws as a source of state authority. In their words, they acted to establish their rule within the framework of traditional law. The first thing they did is they passed anti-Jewish laws, which enabled a state, which basically was the Nazi Party and the police, to ignore individual liberties. In February 1933, relying on the German Constitution, President von Hindenburg and Chancellor Hitler issued what they called an emergency decree for the protection of the people and the state. One thing you'll notice is all of their laws had really sort of high-sounding titles. But that decree suspended sections of the Constitution affecting freedom of the press and individual rights. But although many of these rights were in suspense, Germany still had a constitution. But the Constitution permitted it to be changed by a 2/3 vote of a quorum of a national legislature, the Reichstag. So the enabling law in March of 1933 that was passed by the Reichstag empowered Hitler to enact legislation deviating from the Constitution for 4 years. By this law, the Reichstag essentially voted itself out of existence and gave Hitler dictatorial powers pretty early, March of 1933. Also in March of 1933, the government passed what was called the Curl Decree. This affected Jewish judges, prosecutors, lawyers, all of whom were denied access to the courts on the following day. The only exception was for those who had served in World War I. And then there was a boycott, a government boycott, of all Jewish lawyers implemented on April 1st, 1933. When von Hindenburg died in August of 1934, Hitler became Führer, the leader and Reich Chancellor. And this action was actually ratified by National Plebiscite. German judges at that point started taking an oath to follow Hitler. This is a picture of the German judges taking an oath to follow Hitler. Obviously, there's no Jewish judges left among the judiciary. These are all white males. And what you'll notice about this oath are several things. One is they're swearing an oath to Hitler personally. They're swearing an oath to be obedient to the Führer and the German Reich and people, Adolf Hitler. They say, observe the law and conscientiously fulfill the duties of my office, so help me God. So there are several amazing things about this. One is they're now swearing to Hitler. They still are saying, so help me God, at the end of their oath, which is one of the most mind-boggling parts of all this. You'll see that they're taking an oath. You'll see the pin on their robes. That's not a German flag pin. That's a Nazi Party pin. So in order to be a judge, you had to be a member of the Nazi Party. This was the oath before the new oath. The original oath had the judges, and by the way, the lawyers had to take the same oath, swear loyalty to the Constitution. But as you can see, the new oath took out any allegiance to the Constitution. They were simply swearing to follow Adolf Hitler. They both maintained the obligation to observe the law and ended with so help me God. So my question to you is, since lawyers had to take this oath, does anybody here think any lawyer refused to take that oath? Okay. How many lawyers in the entire country of Germany do you think refused to take this oath? Lawyers. We got a zero? Any other guesses? Okay, here's the answer. 1. This is one prosecutor. His name is Martin Geiger. He was an attorney for the Confessing Church in Germany, and he wrote in August of 1934 that after careful consideration, I find in good conscience that I'm not able to swear the loyalty oath to the Reich Chancellor and the Führer, and he resigned. He's the only lawyer who resigned. I was giving this speech to a group of students, and of course, they immediately Googled him to see what happened to him. And he did survive the war. He joined the Dutch underground and survived the war. Now, what happened next? The German government passed emergency legislation by executive decree and by actual legislation. All public assemblies were subject to prior police approval. All public assemblies that could pose a potential threat to public order and security were prohibited. A ban was placed on all publications, the content of which was likely to endanger public security and order. And all rights under the German Constitution were suspended by law and replaced by a new law directed against, quote, treacherous acts against the government of the national revolution. Now, the national laws weren't enough, so the cities started preparing their own laws. And those laws excluded Jews from public life and the professions in Germany. This is a picture of a lawyer. This is March of 1933. This is very early on. This is a Jewish lawyer who had complained to the authorities in Munich about the treatment of one of his clients, and this is what happened. He was forced to go through the streets without shoes, which is another degrading part, and with a sign that said, "I'm a Jew and I will never again complain to the police," and he's followed by the brown shirts. So after these decrees in cities and nationally, even more decrees, and these are all written laws. Again, they're making laws and then saying we're following them. There were decrees issued by the Reich ministries covering everything from forbidding Jews to attending theaters and movies, expelling all Jews from German schools, freezing all Jewish property and assets, and organizing Kristallnacht in November of 1938. Now, the Jews weren't alone in this prosecution. The Nazis also prosecuted Romans, otherwise known as gypsies, Jehovah's Witnesses, the mentally and physically disabled, and homosexual persons. In November of 1933, all Jewish newspapers and magazines were ordered to stop publication. All Jewish cultural activities were suspended indefinitely, and all Jewish children were ordered out of elementary schools, and it became a crime for a Jew to possess a weapon. So the legislation wasn't enough, the decrees weren't enough. The next thing the Nazis did is set up, in 1934, a special court. They set up this court, and then the German Supreme Court started interpreting the laws. They set up a special court called the National Socialist People's Court, in which the judge became the state prosecutor and investigator. Judges were retained and appointed not for justice, but because of loyalty to the National Socialist state. The judiciary's own acknowledged purpose, in their words, was to annihilate the enemies of National Socialism. The court had jurisdiction over Germany and then over all occupied territories. According to historians, by 1939, the court, in all courts in Germany, had become a direct tool of the state executive and completely subservient to the Gestapo. And the Gestapo itself never bowed to the principle of control of the police action by the courts. So what was the reaction of the judiciary itself? As we talked about the lawyers, we talked about the laws. What about the judiciary as a whole? Because there were a lot of judges in Germany. What do they do in protest of the conduct of the police and these laws? According to Rabbi Leo Beck, who was the leader of Berlin's Jewish community, he said the universities were silent, the courts were silent. Indeed, as historian and Pulitzer Prize winner Saul Friedlander has observed, not one social group, not one religious community, not one scholarly institution or professional association in Germany and throughout Europe declared its solidarity with the Jews. In 1935, one of the leading lawyers in Germany, and who was a secretary in the government, Dr. Stuckart, basically had this position on the role of judges. He said that these actions of judges, that is, from time to time, that judges would actually decide against the government, that seek to limit the political decisions of the Führer, are in direct opposition to the central legal conception of the National Socialist State, namely the Führer principle. In other words, whatever this Führer said, that was the law. And so he was a very famous lawyer, and he was responsible for drafting the Nuremberg Laws. The Nuremberg Laws were passed in 1935 by the Nazi Party Congress. It was called the Reich Citizenship Law. It deprived all German Jews of citizenship and limited German citizenship to persons of German or kindred blood. And this wasn't some sort of random assignment. This is a chart that was part of the law that explained racial ancestry and took basically the ancestry of the grandparents, and if you had any what was called Jewish blood, you were Jewish, and you were deprived of citizenship in 1935. We're going to go into some little detail later, but they had a preface. This is kind of legislative intent, I suppose. The preface was, the purity of German blood is the essential condition for the continued existence of the German people. That was what they were passing the laws for. That was their intent. And we're going to talk about this when we talk about the role of judges in the judiciary. Article 2 of the Nuremberg Laws said that extramarital relations between Jews and the subjects of the state of Germany or related blood is forbidden. So at that point, Jews had no legal rights, and their voting rights, as a consequence, were abolished. At that point, a decree ordered the dismissal of all Jewish professors, teachers, physicians, lawyers, and notaries, even those who had been excluded by the Curl Decree. And these laws, as we said, prohibited intermarriage and extramarital relations between Jews and non-Jews. The penalty was death. And all these laws were enforced by the police. I've done a lot of research on this, and the scholars are uniform in concluding that the judiciary and judges fully cooperated in these actions against the Jews. And in fact, Germany broadly interpreted and enforced these Nuremberg Laws. So I take as an example, there's an opinion by the German Supreme Court in December of 1936. So again, still pretty early on. And it's a dramatic example of the aggressive interpretation of the law by the judges. So we've seen that this law prohibits extramarital relations, but the question was, what does that mean? And there was an ordinance passed by the government that said, well, what that means is sexual relations. When we mean extramarital relations, we mean sexual relations. So the German Supreme Court had to decide, what does sexual relations mean? And they said, well, that's really left for the courts to decide. So here's a couple questions for you. Here's the first question. In defining sexual relations, is bodily contact required? It's a show of hands. Do you think bodily contact is required for sexual relations? We have, it seems, a consensus. But that's not what the Supreme Court of Germany decided. They decided in this opinion, which would come into play later in the trial depicted in Judgment at Nuremberg, as sexual relations consisted of any act that satisfied sexual urge, a verbal proposition for sex violating the law, and the crime did not require bodily contact. Now, in reaching this decision, this is a written Supreme Court opinion, and they go through this whole analysis of, it's just so hard, you can read this, defining what sexual relations mean, and they're not going to limit it to intercourse, because it's really hard, because you have to obtain evidence and be delicate, and so here's the key, a wider interpretation is required here, because the provisions of the law served not only to protect German blood, but also to protect German honor. So they're interpreting this law in the broadest possible sense. So later, when the war ended, we'll see the German judges said, we were just applying the law. We didn't interpret anything. This shows this is just not true. By 1942, the German Ministry of Justice announced that the Fuhrer had the right to intervene in all judicial rulings over and above all existing formal arrangements. In other words, the Fuhrer by 1942 could just decide whatever the Fuhrer wanted in court. And of course, from early and then certainly by late 1942, Jews were not subject to the court's jurisdiction because they were all deemed to be, in the words of the government, an inferior people and not worthy of the rule of law. This is, again, to emphasize the broadness and the breadth of the ruling. They said any act that satisfied a sex urge violated the law. It applied even extraterritorially. It could be abroad. Intent was irrelevant. And a verbal proposition for sex violated the law. That is, sexual relations included a proposition. And it did not require bodily contact. So, one of the questions that arises is, what was the underlying rationale that supported the judiciary's role as an instrument of state power? So these are what the scholars say. There were essentially three principles that were held to be axiomatic for the entire field of administration as well as the judiciary. The principle of absolute rule by the Fuhrer, the principle of authority of the party, that is the Nazi party, over the state, and the influence of race as the fundamental principle guiding affairs of state, that is racial inequality. Another historian agrees the purpose of the law in the eyes of the Nazis was not to apply long-held principles of fairness and justice, but to root out the enemies of the state and to express the true racial feeling of the people. According to one historian, the first and foremost task of the judiciary was to subordinate itself to the totalitarian will of National Socialism. So, one comment I should make now, since you've seen these slides, is that I did do a program with a National Memorial Holocaust Museum in Washington, D.C., and they gave me permission to use those slides. So the slides you've seen so far are all from the Holocaust Museum in Washington, D.C. So we covered the lawyers, we covered the judiciary as a whole and their sort of underlying theme and their rationale, but what about individual judges? What was the role of individual judges? So again, how many judges do you think resigned in protest? Said, I'm not going to sign that oath. I'm not going to carry out these laws. One. That's pretty good. The leading, I've searched high and low for this because I wanted to find some. But the leading author on this subject says, the German legal profession, above all judges, have fully succumbed to the power of corruption, and not in the material but in the ethical sense. And he describes it as the judges entered a moral abyss. And he concluded that not a single judge, not one, appears to have resigned in protest. Not one. Now, I continued to look, and I couldn't find any confirmation that any judge actually resigned in protest. One judge, I found, did complain to the authorities about what he called injustice masquerading in the form of law. He was objecting to the treatment of the mentally ill, and he was allowed to retire in late 1940 with a full pension. And then I found a woman who said her father was a judge in Marburg, Germany, but he refused to join the Nazi Party in 1936, and he lost his job, and then he became a court messenger. So within the number of judges who resigned or retired was none, or one, or two. The total is obviously meager. The German judges who continued to perform their jobs without question did the work of the Nazis. The president of the court made no secret of this. He declared, "The German judicial system can take pride in being the first branch of government in the Third Reich to carry out in its personnel policies throughout the Reich and at all levels of civil service the principle that the movement, the people, the state are one." And the scholars agree that the judiciary largely contributed to its own demise. In particular, it actually promoted its own takeover by close cooperation with the police. In the words of an historian, the judiciary complied with the Nazis with zeal. So the next question is why, right? Why did the German judges so willingly coordinate themselves in the Nazi system and enforce its doctrines? One scholar says, as Nazis, they believed that a state was not only empowered but also obliged to override individual civil rights in the interest of creating an ethnically homogeneous nation. This is historian Claudia Kuntz, and she stated that the Nazis denounced the idea of universal human rights, saying not every being with a human face is human. As she describes, this belief expressed the bedrock of Nazi morality. This morality was a combination of biological theories and racist passions. Kuntz powerfully wrote, "Ethnic Germans were exhorted to expunge citizens, deem alien, and to ally themselves only with people sanctioned as racially valuable. The road to Auschwitz was paved with righteousness." Kuntz's explanation joins many other theories on why Nazi civil servants coordinated themselves within the Nazi system. Why would many of the same people who were judges before Hitler took power make decisions according to Nazi doctrine? Were their actions driven by nationalism, by racial pride? Were they concerned their careers were threatened? Did they seek to advance their own careers? Were they afraid? Were they afraid of the Nazis for the safety of themselves and their families? Were they just following orders? German judges after the war said, we were just victims. We were only following the law. Those judges argued they did not have the power of judicial review of executive and legislative acts, and their only job was to follow and interpret the law. I think as we've seen, and I'll try to demonstrate later too, this just isn't true. The German judges took great pride in how they followed Nazi doctrine and interpreted very broadly. One of the benefits of speaking and learning about this subject is I get to talk to amazing people. And so I was on a program with Nobel Prize Peace Laureate Professor Elie Wiesel, and I asked him what he thought was the major shortcoming of Nazi judges. And he said that the German judges ignored the impact of their decisions on individual people and demonstrated a total absence of humanity. He also correctly, I believe, said that even if they had these qualities, they lacked courage to effectuate them. So whatever the reason or a combination of reasons, it's manifestly true that the German judges coordinated themselves into the Nazi system and were ethically corrupt. As succinctly stated by a leading scholar, the principle of the rule of law is not compatible with that of an authoritarian leadership. As she observed, judges became immediately answerable to the Fuhrer. This reality represented the climax of the destruction of judicial independence. Now, as we know, after the war, there was the Nuremberg trial, the main Nuremberg trial, took place in Nuremberg, Germany. And the question I sort of wondered was why did it take place in Nuremberg, Germany? It turns out there are both symbolic and practical reasons for that. The first is symbolic. This is a picture of the Nazi party grounds in Nuremberg. This was probably 1934, 35, and there are hundreds of thousands of people that would parade in these grounds. It was a big military ceremony. They had school children and all sorts of festive activities, but by and large it was a military show. The other reason is practical. This is a Palace of Justice in Nuremberg, Germany, so they had an existing courtroom where they could hold the trials, and they had a prison in the back of the courtroom where they could actually house the defendants. This is Robert Jackson, who was the lead prosecutor of the Nuremberg trials. He, as many of you know, he was a justice on the United States Supreme Court, and was asked to be the lead prosecutor by President Truman, and he did that with great effectiveness. This is a picture of the courtroom facing the judges. Justice Jackson is on the right, on your right. If you ever get a chance to read his opening statement, it's one of the most eloquent statements by a judge I've ever read. This is a picture of the dock of the defendants. In the upper left-hand corner is Hermann Goering. He was the highest-ranking Nazi official tried at Nuremberg. The others were either dead or missing at that point. The most famous missing one, of course, was Adolf Eichmann, who was captured in 1959 in Argentina, then taken to Israel for trial in 1960. What I wanted to, because of the subject matter, what I wanted to do was talk about the trial after the main trial. So after the main trial of the principal defendants, there were more trials of Nazis conducted in Germany. 12 of these trials were prosecuted by the United States in Nuremberg. The judges in those cases were all state court judges from the United States. The defendants in those trials included doctors who performed experiments on concentration camp inmates, the perpetrators of slave labor, the administrators of the camps, the members of the Einsatzgruppen, which was the SS elite guard who conducted genocide. There were 23 military officers in charge of these killing squads who murdered over 2 million civilians, basically in Eastern Europe and Russia. One of the chilling points about the Einsatzgruppen is that most of them, are the leaders of these killing squads, they would line people up and they'd make them dig their own graves, and then they would shoot millions, it turned out well over 1 million people. The majority of the Einsatzgruppen leaders had a legal education. There are also trials of industrialists and military leaders who were tried for the deaths of POWs and civilian hostages. Now, the movie Judgment at Nuremberg, anybody seen this movie or the play? A few people. To show how aged I am, I showed this movie poster to my class, who are, of course, pretty much 20-somethings. And these were the leading actors and actresses of the time. This is a sidelight, but it was Spencer Tracy, Burt Lancaster, Richard Widmark, Marlene Dietrich, Judy Garland, Maximilian Schell, and Montgomery Clift. There were some other people in the movie, too. They didn't make the movie poster. The only name that my students recognized was Judy Garland. So it really makes you feel kind of old. They didn't know who Spencer Tracy was. But basically, the movie Judgment at Nuremberg and the play dramatized the post-World War II trial of 14 German judges, prosecutors, and members of the Ministry of Justice. And they were charged with war crimes and crimes against humanity through the abuse of the judicial process and the administration of justice. What I want to focus on, of course, is the trial of the judges. They were before, as I mentioned, the Tribunal of American State Court Judges, and a German court's decision in 1942 was the focus of the movie. The principal defendant said he decided cases based on the evidence, yet this is in the trial of this judge Oswald Rothhag. The opinion emphasizes that before trial, The judge made public and private comments, committing himself to find the defendants guilty, and during trial he regularly conferred with the SD, which is the security service of the SS, about the case. Throughout the trial, the judge was the antithesis of an impartial judge. The tribunal concluded that Rothak was sadistic and an evil man. He found him to be a knowing and willing instrument in persecution and extermination of Jews. Now, that was the movie, but actually it dramatized a real case. It was the real case portrayed a relationship between a Jewish community leader in Nuremberg, who was a landlord, and there was an Aryan woman, a younger woman, who lived in his apartment building. They testified they were just friends. The only physical contact was they greeted each other, they kissed each other when they met, and one time she sat on his lap. The man was convicted and executed for racial pollution. The case was referred to, it was called the Katzenberger Case. It was decided by the Special District Court of Appeals in Nuremberg. The defendants were Leo Katzenberger, who, as I mentioned, was a German Jew and a merchant, and he was the leader of the Nuremberg Jewish community, and a woman named Irene Saylor, who was a 32-year-old Aryan married and owner of a photography shop. Katzenberg was found guilty and executed. Saylor was sentenced to 2 years of hard labor and loss of her civil rights. But I went back and read the written opinion in the Katzenberger case. It's chilling. It's written by a judge. 2 other judges concurred. It has all the trappings of a legitimate court opinion. It identifies the parties and the charges, and then lists and discusses findings. Each section is headed by a Roman numeral. The first finding in part is that Katzenberger is fully Jewish and a German national according to the Nuremberg Laws. Saylor is a German citizen of German blood. The opinion describes the charged continual extramarital sexual intercourse with each other. The opinion summarizes the defense, the testimony of the defendants, and all the other witnesses. The court rejects excuses of the defendants, concluding that their descriptions of their relationship as non-sexual defies common sense. The opinion characterizes the defendants' relations with each other as of a purely sexual nature with continuous sexual intercourse. Of course, they didn't just do this on their own in 1942. They relied on the 1936 Supreme Court opinion. And they said, well, that's our Supreme Court. And explained that even if no sexual activity occurred, the Nuremberg laws were still violated because these acts satisfied sexual urges. And as we've seen, this German Supreme Court decision had a very broad interpretation because the provisions of the law require protection of the German blood and German honor. The next section of the Katzenberger opinion goes through the policies and the laws and applies the law to the facts. Sound familiar? And this is how it concluded. The political form of life of the German people under National Socialism is based on the community. One fundamental factor of the life of the national community is the racial problem. If a Jew commits racial pollution with a German woman, this amounts to polluting the German race, and by polluting a German woman to a grave attack on the purity of German blood, the need for protection is particularly strong. And it concludes by saying, as the only feasible answer to the frivolous conduct of the defendant, the court therefore deems it necessary to pronounce the death sentence as the heaviest punishment provided by Article 4 of the decree against public enemies. So I want to conclude with a couple things to meet the time here, which has been very generous to me, which I appreciate. First is the movie. It's really a terrific movie. Spencer Tracy stars in the movie as the presiding judge of the tribunal. He played a state court judge from Maine. He was calm, dignified, patient, and in full control of the courtroom. His analysis of the case in the movie focused on individual responsibility of the judges themselves, and the human dignity of the victims. The principal defendant in the movie is a judge called Janning, and he's played by Burt Lancaster. It's a movie, so they did not really depict Judge Rothag. They depicted a much more sensitive person who was learned and reflective and willing to accept responsibility. So the movie ends, and Spencer Tracy gets to deliver the best line of the movie. It's the last line of the movie, which I think really brings home the individual responsibility as judges we all have and as lawyers that you all have. But after Janning explains to the judge that he didn't think it would come to this, namely that enforcing Nazi laws would enable, straight like that, let me get this quote right, would enable the commission of mass crimes against humanity. So he's saying, I didn't think it was going to come to this. I made these decisions. And the judge replies, Herr Janning, it came to that the first time you sentenced a man to death, you knew to be innocent. So I think it's a remarkable capture in a movie of this principle. I wanted to conclude today, as I concluded my remarks in Courtroom 600 this summer. I was trying to decide in Courtroom 600, where the actual trial took place, and they had a room full of judges and lawyers and German judges and ministers from Germany. It was quite an experience for me to be able to deliver that address. But I was trying to decide how to end that speech. And I'm going to end my remarks today in the same way, which is I thought, what better way to end a speech in Courtroom 600 than to quote Justice Jackson? But not Justice Jackson in Nuremberg. Justice Jackson in 1943, before he went to Nuremberg. He wrote this in a case called West Virginia State Board of Education versus Barnett. This is 1943. A year earlier, the United States Supreme Court had decided a case called Gobitis. In Gobitis, the question was whether the state could compel students to salute the flag in school. And if they didn't salute the flag, their parents were criminally liable and the child would be expelled from school. That was the question before the Supreme Court. And in Gobitis, the Supreme Court said, yes, the state has that power. Jackson joins the court, there's all these discussions, and in an extraordinary event, the court takes the same question up in basically the next term, in Barnett. This time, Jackson writes the opinion. And again, the question is, could a Jehovah's Witness student decline to salute the flag? And by the way, the salute to the flag was with an arm raised in a remarkably similar manner as the Nazi salute. And the court then held in a majority that no, the state did not have the power to order a student to do that. And so Justice Jackson, in 2 paragraphs, describes his view of the Bill of Rights. Now think about, this is Justice of the United States Supreme Court writing this, and then he goes to Nuremberg where he's talking about individual rights and human dignity. And this is what he writes. And I think this is particularly important given the audience here today and the membership you have in your important societies. He wrote, the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. And then he wrote a sentence that sings. As a judge, I read this, and I'm sure as lawyers, it just sings. He concluded by saying, if there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. Thank you very much.
Thank you very much. Thank you. I should also say one of your colleagues actually has the original judgment from Nuremberg, and it's a rare book that he's allowed me to show you. So I'm showing
This is the original judgment from Nuremberg. That's in a rare book that somebody brought here. We'd like to thank the judge again. If you guys can give him another round of applause.
Thank you.
So as I was sitting and listening, my mom gave me a copy of a book called Humoner versus Hitler. I don't know if any of you have read this book before, but it is a story about a 14-year-old boy in Germany in 1941 whose older brother had served an LDS mission, with the black name tags, white shirts, for those out there who aren't familiar with it. And his brother had served in England and brought back with him a shortwave radio where he could listen to the BBC at night. So after Hitler had shut down all media, they would sneak into their room and they would listen to the BBC, and older brother would tell younger brother, what you're hearing at school is not what's happening. All of these other things are happening. So Helmut Humoner, as a 14-year-old boy working in a state-run library, got access to the Ditto machine at times when he wasn't supposed to, and made little leaflets, anti-Nazi party leaflets, that he and his friends from church would slide under the doors of other people. He talks about going to church and having the SS there to make sure that they didn't do anything wrong at church. Ultimately, the Nazis caught up with Helmut Humoner and put him to death under torture to ask him who was this grand schemer that was coming up with this plan, and it was just a couple of 14-year-old boys and their older brothers. So I ordered a copy of this book for you, and want to present it to you from all of our societies. It's signed by the author, by Richard Dewey, and again, we're really, really grateful that you were able to come today, and thank you so much.
Thank you very much.